Good evening. We have 19 days until the general strike against Congress. And so tonight, we're going to talk more about the criminal justice reform elements in the blueprint for a better America. My name is Brian. I'm the founder of the American Union, and we're a union of swing voters demanding Congress immediately pass our crowdsourced legislative package, the blueprint for a better America. Now, this legislative package does three main things. It ends poverty, ends mass incarceration, and ends the endless wars. But all told, there's about 50 different policies within the legislative package. And so for these 3 weeks leading up until October 15th, we're going to go through all the sections one by one, give people a chance to ask questions and be better informed about what exactly it is that we're demanding Congress do. How exactly do we end poverty and mass incarceration and end the endless wars? And so the legislative package is based on our 5 duties in the preamble to the Constitution. So to start this meeting, I'd like to go ahead and recite the preamble. I invite you to join with me in remembering the mission statement for the United States. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Those 5 duties make up the 5 titles of the legislative package. And tonight we're going to continue with Title 1, Establish Justice. The reforms under the Establish Justice title of the bill, they cover 3 broad categories. There's police reforms, prison reforms, and prosecutorial reforms. And tonight we're going to continue going through the police reforms that are in the George Floyd Justice Act. And so we've got 4 of them coming up here. Let's see. I'll go ahead and share my screen again. All right. Tonight we're going to be looking at ending the military equipment donations to law enforcement, the prohibition of engaging in sexual acts while acting under color of law, restricting no-knock warrants, and cash bail reform. And so ending military equipment donations to law enforcement is very short. It's one of the ways that we're able to fit so many policies in a few hundred pages of legislation. A lot of them are just repealing policies that are already on the books. And that's the case here. We're repealing the 1033 program that lets the military give surplus to their, gives military surplus. Repealing the 1033 program that lets the military give surplus to police departments. Now, this is a program that has existed, got really ramped up back in the 1990s. This was part of the war on drugs. And the deal for local police departments was basically kind of the deal that you might see on a late night infomercial, where you can get this military equipment for free, just pay for shipping. And you could get things like grenade launchers, mine resistant, armored troop carriers. You could get all sorts of weapons and things like that the military said they didn't need anymore. All you as the local police department had to do was show that you were going to use them and that you had a need for them. And so this plays into the larger picture of police reform, which is, if you give police departments military equipment under the condition that they're supposed to use them, then they will find excuses to use them. Sort of like, you give a young boy a hammer, they try and solve all their problems by treating them like nails. And if you give the police military equipment, it is a direct contributor to the increasing militarization of our police that we've observed over the last few decades. Another part of this is it is a subsidy for the arms manufacturers. It's a subsidy for the military industrial complex, because then you throw more money into the military industrial complex, and we're approaching $1 trillion a year. And then say, whoops, we have extra stuff we didn't need. Let's just give it away for free. which begs the question, why are they buying it in the first place if they don't need it? And so by ending this program and closing that, I don't want to call it a safety valve, but closing that that spigot will hopefully encourage the military to spend wisely and not just buy stuff because they can. So closing this program also ends that sort of subsidy to arms manufacturers. Some of the and this is getting rid of this program is popular. A majority of poll respondents in June 2020, so after the murder of George Floyd, found that a majority wanted to end this program. Only 17% of respondents wanted to expand it. So yes, that's what this legislative package does. It repeals this section of the U.S. Code that authorizes the 1033 program. According to the ACLU, more than 8,000 jurisdictions have received more than $7 billion in surplus military equipment since over the last 2 decades. And not all of these jurisdictions were real. In 2017, the General Accountability Office, they put up a fake law enforcement agency website with a fake address, and they started getting equipment from the Defense Department claiming that they needed it. Some of the questions that come up about, well, should we really prohibit this? Maybe we should just restrict it. Maybe, let them give away extra things, some of their extra things, but just not some of the more militaristic stuff. And again, that just leaves the loophole open. This is the door that is better closed. Because if we're serious about ending mass incarceration and rethinking the way that we do policing, rethinking our commitment to establishing justice, it's best to close this program. So that's what this section of the legislation does. It doesn't repeal the sale. There's a different section, 2576, that allows the military to sell their military equipment. So police departments could still buy it, but they just can't give it away for free. As I used to serve in the state legislature and in county delegations, and it's one thing for elected officials to take free stuff, but when they have to justify the expense, then it gets a little harder to do. So that would provide, it's a little harder to justify paying for something than it is to just take it for free. So a couple other things to mention. This doesn't address fire departments. Fire departments are under a different section. We don't have any problems that I'm aware of with the militarization of the fire department. So they would still be able to get surplus equipment. This also doesn't cover military animals, dogs, horses, mules, and donkeys. The military could still give away their surplus animals for free. So check, and without any questions. All right, we're going to move on to section 117. This is closing the law enforcement consent loophole. Now, this was an issue that really hit the news back in 2018. BuzzFeed News reported that 35 states allowed police officers to claim that a person in their custody had consented to sex or other sexual acts. And that, in fact, dozens of officers who had been charged with sexual assault or sexual misconduct had, in fact, used this loophole to say, well, they consented, so you can't charge me with anything. And it really raises the question of what is meaningful consent, right? Who are the people that can consent to a sexual relationship? And so we have laws, things like statutory rape, that say, based on age differences, that say there is too much of a power imbalance between these people, that the person with the lesser power cannot give meaningful consent, and therefore whether they're too young or under the influence, there's situations where we say they cannot give meaningful consent, and so any sexual act is assault or rape. And that same logic applies to people who are in the custody of law enforcement. You cannot give meaningful consent when someone has full control over your freedom. So this has been an issue that people have been working on for the last couple of years. And in March, Congress largely closed the consent loophole. They did good. They tucked a few paragraphs into a large appropriations act. Again, this is how things get done in Washington, D.C. This is, that's how they pass their policies. They tuck them into some must-pass piece of legislation, which is why we, the people, are using the same style of putting all of these reforms into one take it or leave it offer for all the candidates for Congress in 2022. So they put these reforms, these couple paragraphs, into the legislation, and I'm going to go ahead and share my screen here again, and we'll take a look at what they did. I want to continue to say that it is much better than what they had before. That this is definitely an improvement, and so they added this new subsection C. Whoever, while acting in their capacity as a federal law enforcement officer, knowingly engages in a sexual act with an individual who is under arrest, under supervision, in detention, or in federal custody shall be fined, imprisoned not more than 15 years or both. And again, that is better than what was on the books before. But you notice they use this phrase, in their capacity as a federal law enforcement officer. And previously, the language that had been in the George Floyd Justice and Policing Act that had passed Congress a couple times and was the basis for this language, it had specifically said acting under color of law. So the question is, what's the difference between someone who's acting in their capacity and under the color of law? Well, according to the Department of Justice, acts under the color of law include those not include, quote, acts done beyond the bounds of that official's lawful authority, if the acts are done while the official is purporting to or pretending to act in the performance of their official duties. So what happens if you have a jailer who is off the clock, that they are not actually acting in their capacity of a federal law enforcement officer, but still as a prison official has oversized influence on the people who are incarcerated there? Now, under the plain reading of this law, if they would not be prohibited from engaging in asexual acts with the people under their who are under their control, because they weren't actually in their capacity as a law enforcement officer. And so switching this, broadening this to the under the color of law really sets the very clear intention that when you are a member of law enforcement and you have substantial control over the life of some other person, whether it's while you're threatening to arrest them, or while they're actually under arrest, or while they're incarcerated. And if you have substantial control over someone's life, this establishes the principle that they cannot give meaningful consent to any sort of sexual act or relationship, that it is presumed an act of sexual assault or rape. And another line that was in the original Congress's proposal, but somehow didn't make it into the last, into what actually got it passed into law, was the part about saying that it is not a defense to a prosecution under this section that the other individual consented. They kind of, when Congress actually passed this to close the law enforcement consent loophole, they kind of didn't close it all the way. So the Blueprint for a Better America would be very firm in saying consent is not a defense. And then there's one other section of law where we add this phrase as well, that under the color of law, that it's not anytime that you are purporting to or pretending to act in the performance of your official duties when you have power over someone, that no meaningful consent can be given. And so that is section 117. Okay, we'll move on to section 19 here. All right, section 118 is restricting no-knock warrants. And all right, this section may be cited as the Breonna Taylor Justice Act. You probably remember who Breonna Taylor was and how she died a little after midnight on March 13th, 2020. The police showed up at her apartment to serve a no-knock warrant. And again, in the middle of the night, after midnight, to burst into her house, allegedly looking for an ex-boyfriend of hers, who in fact was already in their custody on the other side of town. And so they started breaking down her door. Her boyfriend, who was there with her and armed, fired a shot through the door to scare off these unannounced intruders. And they fired back dozens and dozens of times, striking Breonna Taylor 6 times, leaving her in her front hallway bleeding to death. Her boyfriend called 911, begging for 911 to send help. That they needed help, they needed protection, and not knowing that the people that the police were already there, that the police had been the one who were trying to break down their door. And the no-knock warrants really emphasizes a lot of issues. It's sort of that are going on in law enforcement. So what do we do about this? Well, Rand Paul, he, as the senator from Kentucky, he introduced a piece of legislation that would ban no-knock warrants. It was sort of only soundbite legislation, because there is not a whole lot of difference between saying, "This is the police, open up," and then smashing a door down, and smashing a door down and saying, "This is the police." The line between a no-knock warrant and a knock and then break the door down warrant is very, very thin. And the reason for that is because the Supreme Court, as part of the war on drugs, ruled back in 2003 that 15 to 20 seconds after knocking, when announcing, was okay to smash the door in. This was in the case of the United States versus Banks. And it was a man that they'd accused of were serving a warrant, might have drugs. And so they knocked on the door, and within a few seconds, when he didn't show up at the door, they smashed the door in. And so he sued all the way up to the Supreme Court. And the Supreme Court said, quote, "On the record here, what matters is the opportunity to get rid of cocaine, which a prudent dealer will keep near a commode or a kitchen sink. Significant circumstances include the arrival of the police during the day. And so the sufficiency of 15 to 20 seconds for getting to the bathroom to start flushing cocaine down the drain, that is when circumstances are exigent, because a pusher may be near the point of putting the drugs beyond his reach. It is imminent disposal, not travel time to the entrance, that governs when the police may reasonably enter, since the bathroom and kitchen are usually in the interior of a dwelling. There is no reason to peg the travel time to the location to the door, and no reliable basis for giving the proprietor of a mansion a longer wait than the resident of a bungalow or an apartment like Banks. And 15 to 20 seconds does not seem like an unrealistic guess about the amount of time someone would need to get into position to start ridding his quarters of cocaine." And then they said, well, once the exigency had matured, of course, the officers were not bound to learn anything more or wait any longer before going in, even though their entry entailed some harm to the building. So let's just think about that logic for a second. The logic is that you need to, the Fourth Amendment that is supposed to protect us from unreasonable searches and seizures. The Supreme Court has said, 15, 20 seconds, that's not unreasonable. And it doesn't matter whether, even if you admit and you acknowledge and you agree that the occupant couldn't possibly get to the door in 15, 20 seconds, that doesn't matter. They say not travel time to the entrance is what matters, but the imminent disposal, the chance that somebody could start destroying evidence. And so if we say, as Rand Paul's bill did, it says we're going to ban no-knock warrants, but still allows for the police to yell, police, open up, and then smash their door down within 15, 20 seconds, regardless of any acknowledgement from people inside, any demonstration of awareness of the people inside, then you continue to have these escalating situations that don't need to be escalated. As we saw in Breonna Taylor's case, when somebody starts smashing your door in the middle of the night, it is quite reasonable to assume that something is going wrong, not to assume that this is some lawful process and this is should be considered normal. There are other cases. We saw one in Minneapolis earlier this year, Amir Locke, where the police burst into his, at like 7 o'clock in the morning, burst into his place, and when he got up, they shot him. There's a man in Texas, Marvin Guy, who waited more than 7 years after defending his home and shooting back when the police burst into his home. He spent 7 years waiting for a trial. There are a number of these cases because the prosecutor in these cases, in these type of situation, has an enormous amount of leverage. And so they, by charging the homeowner with, attempted murder of a police officer or something like that, they can threaten them with huge amounts of jail time and incarceration, and keep them incarcerated for days, weeks, months, years, waiting for their day in court. So the solution is stop breaking people's doors down. This is like literally the goal of the Fourth Amendment, of protecting people, the right of the people to be secure in their homes from unreasonable searches and seizures. And so while while the Supreme Court has said under existing laws and rules, 15 to 20 seconds is okay, we can change what the law is. That is the power of Congress. That is the power of the legislative branch. Congress has the power to fix this, and they are refusing to act. They are refusing to uphold our duty to establish justice and enforce the Fourth Amendment to the Constitution. I guess, it's, as you can probably guess, that of these tens of thousands of no-knock warrants, that they do not get served on people equally, right? When recent search of Mar-a-Lago in Florida, there was no knock warrant. The police communicated with lawyers. Everything was all very, you inform people when you serve a search warrant. The actual service of no-knock warrants turns out to be, the majority of times, for drugs, majority of times served on people of color. The evidence for procuring these no-knock warrants oftentimes come from confidential informants. They are often there. It's not uncommon for them to be served on the wrong address or on the wrong person. And once again, the Fourth Amendment is very clear about the goal of having people feel safe and protected in their homes. And so, especially if you're the wrong person or you live at a completely different address, you shouldn't have to worry about the police knocking down on your door. They should be knocking and introducing themselves and saying, we have a warrant to search this premise. And then you can say, no, I'm sorry, it's the street, it's the house across the street, you have the wrong address. there's just and as many states have beefed up the castle doctrine, the idea that wherever you are, your home is your castle, and you have a fundamental right to defend yourself in your castle. You can see how this conflicts with these two things conflict. And the people who get caught up in this are typically people of color, people in poverty, people who it disproportionately affects the same communities that the war on drugs is affecting, and serves as a mean of terrorizing those communities. The idea that someone can legally come bursting in your door on the basis of whether it's a confidential informant on with really no real protection against that. So here's what the Breonna Taylor Justice Act does. Defines that all right. Okay, notwithstanding any other provisional law, a federal law enforcement officer may not forcibly enter any occupied dwelling to serve a warrant unless. And so here's the unlesses. We've got it is daytime, as defined in Rule 41A to B of the Federal Rules of Criminal Procedure. That means from 6 a.m. to 10 p.m. And if you, so this is pretty standard. A judge can override this if for a good cause, but in general, all federal warrants would be required to be served during daytime hours. Or the occupant refuses admittance to the officer pursuant to Section 3109 of Title 18 after having been provided of their notice and purpose. Now, this is the section of law that exists that says you can't force entry into a home unless you have been refused admittance. And the Supreme Court has said, well, after 15 or 20 seconds, you can just assume that admittance has been refused. But the section of law would change that and say, no, you can't just assume that after 15 or 20 seconds. Instead, shall be a rebuttable presumption that admittance was refused to an occupied dwelling if the officer repeatedly and forcibly knocked on their door and announced their presence between 8 a.m. and 9 p.m. no less than 4 times over no less than 3 minutes, and at all other times no less than knocking 6 times over 5 minutes. Now, again, it's not impossible for someone to get to the door within 15, 20 seconds, but it's sure not, it's not an average time by any means. Somebody, may be taking a shower, somebody may be in another room, might be putting kids to sleep, might be cooking dinner, might be sitting around on the couch with no pants on watching TV. There are many, many scenarios where someone needs a little bit of time to answer the door, especially these days in the 21st century where people just knocking on your doors isn't as common. You don't pop over to your neighbor's house maybe as frequently as people did 25 years ago. And so, as someone who has knocked on a lot of doors while campaigning, I can tell you that, if I knock on your door, I'll give you about 30 seconds, and then I'll knock again, and then I'll give you about another 30 seconds, and then I'll leave a note on your door and some campaign literature. But that, to me, is someone who is not necessarily looking for a certain person as much as I am trying to interact with as many people as possible. A minute is the amount of time before I would give up and move on. For the police serving a search warrant, 3 minutes to give someone a chance to answer the door is a very reasonable amount of time during normal hours. At 6 a.m., somebody's asleep, right? 5 minutes is a reasonable amount of time. Again, this would require or say for admittance was refused. So if the person comes to the door, opens it and sees the police, then closes it and goes back inside, then admittance is refused. And so under that scenario, the police would then have the authority to break down the door because admittance was refused. But you can't just assume after 15 and 20 seconds that that the occupants inside have made a conscious and willful decision to refuse admittance to the officers. That is not reasonable by any standards. So as we've talked about, the blueprint is a federal piece of legislation and it only applies to federal law enforcement. But the way that we can influence states to adopt these same policies is by threatening to withhold grant money. And so subsection D would limit the eligibility of funds beginning in 2025 so that a state or a local government could not receive funds from the COPS grant program unless they had a law that prohibited the issuance of a no-knock warrant in drug cases and restricted the other use of no-knock warrants to daytime hours. And so this is the way that we incentivize states to adopt similar policies and to stop using no-knock warrants for drugs cases. There are a number of members of law enforcement who have called for this as well, because they recognize that breaking into someone's home is an invitation for violence, an invitation for somebody to start shooting back when you burst down their door. And so a much better situation comes when you de-escalate things, when you try and talk and communicate with the people inside instead of just breaking down their door. I think that concludes everything on section 118. As I mentioned, and as we'll talk about more next week, I think the Blueprint for a Better America ends the federal war on drugs. And so that's why there's nothing prohibiting the service of no-knock warrants for drug cases, because those drug cases will be going away. On the state level, states will be able to set their own drug policies. And so the blueprint adds that restriction to withhold COPS grant money if they are not in service of a unless they block it for the purposes of drug crimes. Okay, seeing no questions, I'm going to move on to section 119, which is cash bail reform. And it is, section 119 is basically just one sentence. It says that federal cash bail is abolished, that no court created under Article 3 of the Constitution may use payment of money as a condition for pretrial release in any criminal case. Let's talk about cash bail reform. There are right now, this very moment, there are hundreds of thousands of people that are incarcerated right now, not because they've been convicted of any crime, but because they're waiting for their day in court, because they can't pay their bail. Remember in the last section, I mentioned Marvin Guy in Texas, who's been waiting 7 years for his trial. He's being held on $4 million bail. And unless you're one of the top 1% that can come up with millions of dollars to bail yourself out, that bail amount is not a legitimate, that bail amount is just capricious. It is just a way of saying, look, if you could jump this high, you could get the key and get yourself out. But there's no reasonable way that people can raise millions and millions of dollars for their bail. And so it is just an excuse. It is used as a way to punish people, to incarcerate them without convicting them of a crime. As I said, he's been in prison and jail for 7 years waiting for his day in court to prove that it was self-defense when he shot at the people that came bursting through his door. And so there are hundreds and thousands of these cases. And Brian Stevenson, who's the author of Just Mercy, he said the opposite of poverty is not wealth. The opposite of poverty is justice. And so this cash bail reform would help establish the principle that no one should be held in jail simply because they can't afford to pay money to get out. That the purpose of incarcerating someone is either for rehabilitation after conviction of a crime or for public safety, to ensure that they are not a threat to anyone or society. But the inability to pay doesn't change. Cash bail, obviously, all this is to ensure that people return to court. That's the purpose of bail. But it is not a purpose for pre-conviction punishment. And so that's the way that it has been frequently used. We'll talk about Caleb Browder a little bit more when we get to the solitary confinement reform sections. But he was a teenage boy in New York, and he spent years on Rikers Island because his family was unable to pay his $3,000 bail. And during those years, he spent several of them in solitary confinement before eventually, the police dropped the charges. And so we see that the purpose of cash bail isn't the real purpose of cash bail is revealed as a way of pulling self-service convictions, of holding someone and, consider what happens if you're in jail, right? Your life unravels. You don't show up to work on Monday. Maybe you don't have a job anymore. Your relationships, your kids, who's going to take care of your kids if all of a sudden you're now incarcerated? Your apartment, you got to still pay your rent, utilities, everything else like that, or you're going to lose it. Incarceration is inherently destabilizing to people's lives. In 2015, Sandra Bland was driving through Texas on her way to start a new job, and she got pulled over for allegedly failing to use a turn signal, found herself incarcerated, and when she couldn't come up with the $500 bond by Monday, she missed out on starting her new job over a few $100s and an alleged failure to use a turn signal. And then she was found dead in her jail cell not long after that. This is inherently destabilizing to people's lives. If you want to establish justice, if you want to give a person a chance to defend themselves, they need to be able to talk to witnesses, collect evidence, things that you can't do while you're in jail. And so, we talked about the law enforcement consent loophole and the inability to give meaningful consent. How can you put on a meaningful defense if you're locked in a cell and unable to coordinate that defense, to do research, to do any of those kind of things? Some of the, and this is a symptom of a larger problem in our judicial system, where trials can drag on forever. That it can take, as you see in many cases, it can take years for someone to get their day in court. And it didn't always used to be this way. As I read the history of things like the civil rights movement, it amazes me that Rosa Parks, when she got arrested on December 1st, 1955, for refusing to give up her seat on that Birmingham bus, that she was arrested, and then she got her trial on Monday. She got arrested on Thursday, and Monday she got her day in court. And this really helps get us to establishing justice, moving up making trials speedy again, because that's when information, when knowledge, when memory is fresh. When you have cases that drag on for years and years, witnesses move, witnesses die. Justice is much harder to establish. And so cash bail reform is, again, holding people, these hundreds of thousands of people, holding them on cash bail is a way of getting self-service convictions out of them, that, you know, your life is unraveling, so just plead guilty to this lesser offense and you can go. You know, this is sort of a contradiction in terms here of saying, well, we have to hold you unless you give us money because you're too dangerous to be released. But if you just plead guilty to this thing, then you can go. And so we see the absurdity of holding so many hundreds of thousands of people like this. There was a study in 2017 in Harris County, Texas. It's the third largest county. And they found that people who were unable to meet bail were 25% more likely to plead guilty and 43% more likely to be sentenced to jail. Again, no one should be held in jail just because they can't afford to come up with a certain amount of money. That's not what jail is. And again, people's lives unravel. People cut deals, take deals in order to try and put these situations behind them. However, in a lot of cases, those plea deals that they take in order to get out of jail without paying money immediately often come with a lot of terms and conditions, because they're sort of like the terms and conditions that we all have to sign when we log onto websites or buy software, things like that. You agree to all of these things? Again, you have no meaningful way to say, no, I don't agree with these terms and conditions. And it's pretty much the same way when you take a plea deal in order to get out of jail, that you just have to accept these are the terms and conditions, which may mean that if you're pleading guilty to something, that you can lose access to rental assistance, to food stamps. You may have a criminal conviction that may make it harder for you to get a job. You may lose your eligibility to vote. There are all sorts of ramifications and consequences. And again, holding someone in a jail cell until they accept this deal, or offering to let them out only if they accept this deal, is inherently coercive. But unfortunately, because of the way that the judicial system is set up and is backed up these days, it's become a very necessary part of how the judicial system works. That something like 95% of cases are resolved with a plea deal. That the courts can't possibly give everyone who's arrested their day in court. And so there's a fundamental problem with the way that we are establishing justice, or failing to establish justice. And so by abolishing cash bail, you will force prosecutors to be more mindful in the charges and things that they bring. Right now, one of the things that we often see is a prosecutor can throw a lot of charges at someone and then use that as a way to persuade them to take a plea bargain. But if by bringing the focus back to charging someone only with the things that they've actually done and that you could actually prove in court, will help us better establish justice. All right, so you might be asking, what about cash bail reform on the state level? And that is dealt with through eligibility with the Byrne Grant program. And so we'll talk more about how the states are going to be encouraged to also adopt cash bail reform starting tomorrow. Cash bail reform is one of these issues in the news that news media likes to use for fear mongering. But the evidence is very clear that the vast majority of people who get out as a result of cash bail reform do not go on to commit other crimes, do not commit other violent crimes. There is a non-zero amount, but freedom isn't free. Freedom requires that we be willing to, you have to accept risks with freedom. And so the idea that we should incarcerate 100 out of 100 people to make sure that 2 of them don't commit to discourage 2 of them from committing a crime, we miss all the extra societal harm that is being caused by unnecessary incarceration, right? No news media outlets do stories on the kids who had their parent home to read them a story at night, or were able to show up at their Little League game, or help them with their homework because of cash bail reform. Those kind of things don't make stories, but those are the actual stories that help us build stronger families, stronger communities, and address the crime problem that way instead of trying to incarcerate our way out of it. Cash bail reform is again, the evidence is there that it works, that it helps people get back into their lives. And again, think about how your life would be destabilized if just like that you got locked up for 3 days, 5 days, with no warning. And so what are the things in your life that would start to fall apart? And again, the purpose of the criminal justice system is to rehabilitate people, help them be better members of society going forward. And so it's a lot harder if you start destabilizing people's lives. It's a lot harder to do that sort of thing, right? If you've lost your job or whatever, then you're just creating more problems in someone's life. So cash bail reform is an essential part of ending mass incarceration. It's an essential part of the blueprint for a better America to end poverty, end mass incarceration, and end the endless wars. I encourage you to join the general strike against Congress on October 15th. This will be observed with a day of fasting, a fast for peace, as a part of my commitment to helping de-escalate the 2022 midterms. This is the 3rd day of my fast. I will not eat until October 15th, the next 19 days. And my weight's down to 197 today. But I'm feeling good, and I'm just as committed to offering the American people an opportunity to come together around solutions, to say, look, Congress, get this done. Put this on the president's desk before the midterm elections, and we can reelect all of you. Doesn't matter, Republican or Democrat, we just want to see problems solved. Congress has the ability to act, and they're refusing to do so. And so we can pressure them, force them, inspire them to act before the election by using our votes as leverage. If they refuse to act, then their major party opponents can get the American Union endorsement and corresponding block of votes. This is how we can finally address Martin Luther King's triple evils of poverty, racism, and militarism, by putting all these policies, all these reforms into one legislative package and demanding Congress pass it. So I think that covers everything tonight, those 4 sections of the bill. And tomorrow we will continue going through the last part of the George Floyd Justice Act, and continue going through on all these policies. So thanks. I look forward to seeing you all tomorrow.